Okay, good afternoon, everybody. Welcome to the 27th Annual Symposium on the Holocaust and Genocide. I wanted to introduce our speaker for this afternoon, Professor Irwin Cotler. He's the founder and chair of the Raoul Wallenberg Center for Human Rights, an emeritus professor of law at McGill University, former member of Parliament, former Minister of Justice and Attorney General of Canada, and an international human rights lawyer. As minister, Professor Cotler headed the Canadian delegation to the Stockholm Conference on the prevention and combating of genocide and made the pursuit of international justice a priority for Canada, including initiating the first ever prosecutions for incitement to genocide and the commission of mass atrocity crimes in Rwanda. So I'd like to welcome Professor Cotler. I also want to mention that we are being live streamed to John Abbott College, to Champlain College, St. Lambert, to Champlain College, St. Lawrence, and to Cégep Saint-Île. So I'd like to welcome everybody who's watching, and I'd like to introduce Professor Cotler.
Thanks. Thank you, Marlene. It's a pleasure to be here and to once again have the privilege to participate in this annual symposium. And I want to commend you, Marlene, and those of your team who have brought together such an excellent set of speakers and respondents. And I know you had the pleasure yesterday of hearing a real hero of our time, Shaprak Shaparazi. I'm delighted that she's here with us today, a former Iranian political prisoner who escaped, is here now in Canada, and we are the beneficiary of her great human rights involvement and dedication. So thank you, Shaprak. It's a pleasure to have you not only come and speak, but to partake of this important annual symposium. As it happens, we meet at a rather important moment of remembrance and reminder. April has been set aside in the Canadian Parliament while I was there as Genocide Prevention Month. Regrettably, I noted that the beginning of Genocide Prevention Month, which was yesterday, has almost passed unnoticed, unacknowledged, and unaddressed. Yet this month alone commemorates the Holocaust, the Armenian genocide. We are on the eve, for example, of the 25th anniversary of the Rwandan genocide. And of course, we have the Ukrainian Holodomor and the genocide in former Yugoslavia. So this is what Genocide Prevention Month was intended to commemorate. Those are the 5 genocides that were recognized by Canada at the time that Genocide Prevention Month was established. But since then, Canada and the Canadian Parliament became the first parliament in the world to recognize what has been happening to the Rohingya of Myanmar as also being a genocide, and recognized as well the pain and plight of the Yazidis that is continuing also as we meet as being part of that horrific catalog of genocides. And as I mentioned, we meet days before we will be commemorating the 25th anniversary of the Rwandan genocide, the genocide of the Tutsis in Rwanda, where from April 7th to the end of June 1994, 10,000 Tutsis were murdered every day for 3 months. And what makes the genocide of the Tutsis in Rwanda so horrific is not only the horror of the genocide itself. That would be bad enough. What makes it so horrific is that this genocide of the Tutsis of Rwanda was preventable. Nobody could say we did not know. We knew, but we did not act. Just as in the case of Darfur, we knew, but did not act. Or in the case of Syria, where right now we are commemorating, in effect, the 7th anniversary, 8th anniversary actually, of the beginning of the killing fields in Syria, which began in March 2011. A group of young people who marched with olive branches saying, peace, peace, dignity, dignity. They were gunned down by Assad and his criminal associates. Other young people took their place. They too were gunned down and disappeared. And now, 8 years later, the 8th anniversary has gone almost unnoticed, yet over 600,000 have been killed. More than 12 million Syrians have been displaced, more than half the population, and more than 6 million refugees. The worst humanitarian catastrophe since the end of the Second World War. Not only it has gone unaddressed and unredressed, but almost unacknowledged. And as I mentioned, the Rohingya, whom as we meet, are themselves suffering in a state of dispossession, and all they seek is a protected return to their protected homeland. So there is this backdrop with respect to the whole question of the Holocaust and genocide, to which I will return at the close of my remarks. But my theme today, because this is also going rather unaddressed, is the danger of the resurgent global authoritarianism on the one hand, the retreat of democracies, if not almost the value of democracy on the other, and the concomitant assault on human rights, which criminalizes in particular fundamental freedoms and freedom of expression. And I recall when I was a student at law school and we studied an important case on freedom of expression, Switzman and Ebling. But I recall in that case, Justice Rand of the Supreme Court of Canada saying at the time that liberty in these things, that is to say, liberty in matters of freedom of expression, is no less vital, as he put it, to man's existence, one today would say men's and women's existence, than breathing is to their physical existence. In other words, the importance of freedom of expression as a fundamental value, as a value that defines who we are, as well as what we can aspire to be. So what I thought I would do today is share with you 4 case studies of the resurgent global authoritarianism and the retreat of democracy at the same time, and looking at this dynamic through the looking glass of the pain and plight of political prisoners, who themselves serve as dramatic case studies of the resurgent global authoritarianism on the one hand, and the absence of the community of democracies coming to act on their behalf on the other, and to combat that larger global resurgent authoritarianism as they protect and need to protect fundamental freedoms. The 4 case studies that I'll share with you that are unfolding as we meet today, and the political prisoners respectively in those 4 case studies is, first, the situation in Venezuela, and we'll look at that through the looking glass of the presently imprisoned leader of the democratic opposition in Venezuela, Leopoldo Lopez. We are marking and marked recently the 5th anniversary of his arrest. We'll then look at the case of Iran, which in 2018 had an almost unprecedented, massive domestic repression And in that context, we'll look at the trial of 8 environmentalists in Iran that is taking place as we meet, and the particular plight and pain of Nasrin Sotoudeh, the iconic human rights lawyer in Iran, who has gone down the line on behalf of other women, including Shaparak. She was Shaparak's lawyer, on behalf of juveniles destined for execution, on behalf of journalists, on behalf of human rights defenders, on behalf of other lawyers, on behalf of other political prisoners, until she herself has become a political prisoner, part of the massive set of arrests in the summer of 2018, and was recently sentenced to 38 years in prison and 148 lashes for a woman in her mid-50s, a virtual death sentence. We'll then look at Saudi Arabia, the case of imprisoned Saudi blogger Raif Badawi, and we will conclude with China and the case of the longest-serving political prisoner in China, Dr. Wang Bizang, and his particular Canadian connection, and see it also through the eyes of Tiana Wang, his daughter, who sought to recently visit him in prison. I just might add, parenthetically, that in each of these cases of political prisoners, I've had here the privilege to be acting as international legal counsel on their behalf, and the Raoul Wallenberg Center has taken up their case and cause. So I'll be drawing upon that experience to share these 4 case studies with you. Let me begin with the case of Venezuela. Venezuela, regrettably, was, I say regrettably, in terms of the transition from having been a leading democracy in the Americas in the 70s to having transformed into a dictatorship, a Maduro dictatorship, which tells you something about the vulnerability of democracies and the resurgence of global authoritarianism. Now, some 20 months ago, I was appointed, along with 2 judges from Latin America, Judge Santiago Canton from Argentina and Judge Emanuela Ventura Robles from Costa Rica, as part of what was characterized as an independent panel of legal experts established by the Organization of American States, of which Canada is a member, to look into the question as to whether crimes against humanity were being committed in Venezuela, and if so, what the international community needed to do about it. And so we examined the documentary evidence from intergovernmental organizations, governmental NGOs, and the like in Latin America and beyond, United Nations reports, UN High Commissioner for Human Rights, and the like. And we held public hearings in Washington and heard witness testimony. And at the end of our inquiry, and in May 2018, we're a month away from the anniversary of our report, we reported that there are reasonable grounds to believe, which is the threshold for criminality set forth in the statute for an international criminal court, that there are reasonable grounds to believe that 7 major crimes against humanity were being committed in Venezuela, including multiple cases of murder, the widespread and systematic targeting of civilians as a matter, an instrument of government policy, singling out in particular those who are members of the opposition or deemed to be members of the opposition or not sufficiently supporting the dictatorship. which included over 6,000 cases of extrajudicial executions among the multiple cases of murder. We also found 12,000 cases of arbitrary arrest, imprisonment, and deprivation of liberty, which is continuing as we meet. Hundreds of cases of torture of a kind and character that Justice Robles of our panel said that in his 25 years of being a judge, he had never seen such horrific state-orchestrated torture. We also found crimes against humanity that included rape, disappearances, the commission of such crimes on persecutorial grounds, and finally, and perhaps the worst, because the one that not only is continuing as we meet, but the one that has been least appreciated as a crime against humanity, and that is state-orchestrated humanitarian suffering, the weaponization of food and medicine, particularly depriving, as I said, opponents of the regime of such food and medicine, such that we have been witnessing in Venezuela, and we reported and documented this, hundreds of thousands of preventable diseases and deaths. And where in 1 year, for example, from 2016 to 2017, there was a 50% increase in maternal mortality, a 30% increase in infant mortality, the return of diseases that had long since been prevented and protected against in Venezuela. I'm referring to diseases such as diphtheria and tuberculosis and malaria, and as I said, an utter absence and indeed weaponization of food and medicine, which continues as we meet. In fact, the denial by the Maduro regime of humanitarian assistance to Venezuelans as we meet is a continuing crime against humanity and a standing injustice. And as I said, we mark, and recently marked, the 5th anniversary of the imprisonment of the democratic leader of the opposition, Leopoldo Lopez. And we witnessed remarkable testimony on the case of Lopez in our public hearings, and I'll summarize it very quickly, but this will give you a looking glass into what is happening in Venezuela in terms of the complicity of the entire law enforcement system, the courts, the prosecutors in the crimes against humanity, and the utter assault on the rule of law and the utter absence of any independent judiciary. During the public hearings, we heard from Renata Tovar, who had been the judge who issued the arrest warrant for Leopoldo Lopez. She testified to us that she had been ordered by the Maduro regime to issue an arrest warrant on pain of she herself being arrested. We heard from Franklin Neves, the prosecutor in the case, who also had escaped from Venezuela, who reported to us that he had been ordered by the Maduro regime to impose trumped-up charges, false and trumped-up charges against Leopoldo Lopez. That, as he put it, Leopoldo Lopez was utterly innocent of any of the allegations of criminality against him. In fact, as he put it, what Leopoldo's case was a case study in the criminalization of his fundamental freedoms, amongst them, in particular, the freedom of association, assembly, and expression. And so through the looking glass of Leopoldo Lopez, we have this lens whereby we broaden it and bear witness, as I said, to the 7 major crimes against humanity in Venezuela. I'm pleased that consequent upon our issuing of the report, Canada took the lead, and along with 5 other Latin American countries, joined also by France and Germany. And for the first time in the history of the International Criminal Court, last year, 2018, we commemorated the 20th anniversary of that court, there was a collective referral by these states, led by Canada, of the crimes against humanity in Venezuela to the International Criminal Court for prospective investigation and prosecution. It was the first initiative of its kind, and while it marked a belated, nonetheless necessary initiative by the community of democracies. And as we meet today, our Foreign Minister, Chrystia Freeland, is attending a meeting of both NATO, but subsequently of the G7 countries, and one of the first items on the agenda will be the situation in Venezuela, the crimes against humanity, the pain and plight of the suffering Venezuelan people, and what needs to be done in that regard. Which brings me now to the second case study, and that is in terms of Khamenei's Iran. And I use the term Khamenei's Iran because I want to distinguish it from the people and the publics in Iran who are suffering from massive domestic repression. And 2018 marked one of the worst years in terms of that massive domestic repression, what Amnesty International otherwise characterized as a year of shame in Iran, where during 2018, the leaders of 10 major civil society groups, students, academics, educators, journalists, women, leaders of ethnic and religious minorities such as the Baha'i, human rights defenders across the spectrum of civil society in Iran, environmentalists. For the first time, protecting the environment was transformed into a capital criminal offense. So you had the arrest, imprisonment, sometimes torture in detention, sometimes execution of the leaders of 10 civil society groups in Iran. The whole dramatized, as I said, where for the first time, environmentalists, the leaders of the Persian Wildlife Heritage Fund, those who've been dedicating themselves to environmental protection in Iran at a time of environmental degradation in Iran, became themselves the object of national security charges and being subjected to the risk of execution on these national security charges. And so in an incredible Kafkaesque maneuver that would make even Kafka blush at a time that Iran itself is in desperate need of the expertise of these environmentalists. They have been arrested, tortured in detention, had false and absurd charges of such as corruption on earth leveled against them, are at the risk as we meet, as their trial continues in close quarters, of execution, and the whole having been transformed into an Orwellian exercise where those who should have been celebrated for their protection of the environment in Iran ended up being imprisoned for seeking to do nothing else but help the people of Iran. And what makes it so painful, is that in an astonishing acknowledgement, for the first time that I know, even amidst the assault on human rights in Iran, and the false arrests and imprisonment and tortures and detention and executions, and where Iran executes more people per capita than any other country in the world. Even amidst all this, in the case of the environmentalists, the prosecution and persecution has been so false and absurd that even the leaders of the intelligence ministry, who are otherwise responsible for the arrest and prosecution in all other respects, and even President Rouhani, have declared that they are innocent and should be released. That has been unprecedented. And that's why I said it's a kind of situation that would make Kafka blush, because not only do you have the kind of Kafkaesque trial and assault, but even some of the leaders of Iran came to their defense to say that the falsity and absurdity of making environmental protection a capital offense is even beyond their comprehension. And this brings me to the case of Nasrin Sotoudeh. I don't know any other human rights lawyer in the world that has exhibited the moral courage and commitment as Nasrin Sotoudeh. I first became involved in her case when I was a member of parliament, and she was then arrested in 2010, then too on trumped up charges. And we mounted in the Canadian Parliament and otherwise an international campaign of advocacy on her behalf. And she was freed after 3 years of that imprisonment at the time, only to be arrested again, as I said, in the summer of 2018, and this time sentenced, as I mentioned, to 38 years in prison and 148 lashes. And the difference has been that the community of democracies that at least came to her defense in her first arrest has been very slow in mobilizing with regard to this arrest. In fact, what has been so shameful about 2018's year of shame in Iran about the massive domestic repression has been the relative silence and inaction by the community of democracies. And so on December 10th, and Human Rights Day, joined by our human rights hero, Shaparak, who's here with us today, the Raoul Wallenberg Center of Human Rights, together with the all-party Raoul Wallenberg Parliamentary Caucus on Human Rights in Ottawa, came together to hold a press conference to sound the alarm on what has been happening in Iran, to single out the importance and compellability of the imprisoned heroic Nasrin Sotoudeh, to name and shame the major 19 architects of repression in Iran, responsible, as I said, for the false arrests, imprisonment, torture, execution of the leaders of civil society, as I named them earlier before, and to call on governments to impose Magnitsky sanctions on these 19 architects of repression. I regret to say that while civil society in Canada, US, France, elsewhere, has begun to mobilize on behalf of the imprisoned Iranians, the governments of the democracies have been too slow to mobilize on their behalf. Not one of the 19 architects of repression in Iran has been subjected to Magnitsky sanctions. Those sanctions, which are named in the memory of Sergei Magnitsky, very quickly, because I said, how many people here have heard of Sergei Magnitsky? Well, we've got Shaparak and her colleague, not surprisingly that they would. But let me just tell you a word about where it comes from and why it would be important for all of us to appreciate it. Sergei Magnitsky was a Russian lawyer who was acting on behalf of the largest corporate investor in Russia at the time in 2008, Hermitage Capital, a UK-based investment firm. He discovered the largest corporate tax fraud in Russian history. And he named and documented the leading Russian officials in the Interior Ministry, in the Foreign Ministry, in the Procuracy General, who were responsible for this major corporate tax fraud, defrauding the Russian people as well as defrauding Hermitage Capital. Instead of these people being brought to justice, the Russians arrested Sergei Magnitsky, put him in prison, charged him with the corporate fraud, tortured him in prison until he died in that Russian jail as a result of the torture. Bill Browder, who headed up that British investment firm, then made it his life's mission to bring the perpetrators to justice, or to such justice as would be possible. He knew that that justice would not be possible within Russia, because Russia was not only not bringing them to justice, but the very perpetrators were in fact rewarded for their crimes. So he called upon the community of democracies to impose what came to be known as Justice for Sergei Magnitsky Sanctions, which meant that visa bans would be imposed and asset seizures would be imposed on all those who Magnitsky named and documented for their criminality. So they at least would not be able to travel and freely enter democracies like Canada, or launder their proceeds criminally in countries like Canada. As we meet, I'm pleased that Canada became the third country in the world to adopt Magnitsky sanctions. We now have about 8 countries that have done so, but it is not enough. And the march of democracy here, we seek to call upon other countries to enact Magnitsky sanctions. And it was enlarged to not only apply to those in Russia who committed major human rights violations, but now we have what's called global justice for Sergei Magnitsky sanctions, in which such sanctions can be applied to individuals from whatever country that engage in major human rights violations. And so you have Canada imposing Magnitsky sanctions on the leaders in Venezuela, imposing it on those deemed to be responsible for the murder of the journalist Khashoggi of Saudi Arabia, imposing it with regard to Russia, as I mentioned, and these sanctions are beginning to have some impact. Though, as I said, the resurgent global authoritarians, for the most part, have not yet been sanctioned, and I'm referring to Iran, I'm referring to China and the like. Let me go now to the third case, as I was mentioning, Saudi Arabia. And as we meet, we are on the eve of the 7th anniversary of the false arrest and imprisonment of the Saudi blogger Raif Badawi, who was imprisoned 7 years ago for saying then what the Crown Prince of Saudi Arabia started to say, Mohammed bin Salman, last year about the need for a more open Islam, for a more moderate Saudi Arabia. Similarly, women human rights defenders in Saudi Arabia who had sought for the women having the right to drive, the easing of the male guardianship system, were imprisoned while Mohammed bin Salman then, at this point to his credit, then brought about the reform of giving women the right to drive, and yet imprisoned the very women who were the leaders of the movement who called for women having the right to drive. Again, here too, this Orwellian inversion. And just a few days ago, 3 of those women were given conditional release, along with the evidence that emerged that while they were in prison for having sought a reform that the Crown Prince himself implemented, they were brutalized and tortured in prison, where it was sought to secure from them false confessions. And that is going on as we meet. Now, what happened that brings a particular Canadian connection and throws a particular looking glass at what is happening in Saudi Arabia's resurgent global authoritarianism on the one hand, and the retreat of democracies on the other, can be seen through the lens of the case study of Raif Badawi and his sister Samar Badawi, who's one of the imprisoned Saudi women. In August of 2018, our Foreign Minister, Chrystia Freeland, tweeted a call for the release of both Raif Badawi and Samar Badawi. The Saudi authorities erupted in fury for Canada doing something that it had done before. And as we know, Raif Badawi's wife and 3 children, and Safhada and her 3 children, are here in Canada, have secured Canadian citizenship after having come here as refugees. So it was only natural and appropriate that Canada tweet a call for their release. As they put it, this is part of what we do in terms of calling for women's rights and human rights. But the Saudi authorities erupted in fury. They ejected the Canadian ambassador to Saudi Arabia. They recalled the Saudi ambassador to Canada. They suspended all trade and investment in Canada. They recalled 15,000 Saudi students who were studying here in Canada, which only harmed their own students, including medical students undergoing medical training here. But what was the most telling other part of this story is that in the face of Saudi Arabia flexing its inflexible authoritarianism, not one democracy, I repeat, not one democracy came to Canada's defense. And so, as I wrote after the brutal murder of Saudi journalist Jamal Khashoggi in October, that the road to Khashoggi's murder began in August, when, after Saudi Arabia erupted in fury for Canada doing nothing other than asking for the release of the 2 Badawis, and none of the community of democracies coming to Canada's defense, this emboldened the Saudi leadership to believe that they could act with impunity. And that took us down the road to Khashoggi's murder. Finally, belatedly, the community of democracies awoke, and sanctions were imposed on the 17 Saudi officials deemed to be responsible for Khashoggi's murder. Further sanctions were imposed by the US and other countries, unanimous condemnations through the European Parliament and the like, and therefore a belated accountability. But the Badawis are still languishing in prison, and we have to raise the voice and involvement of the community of democracies to secure their release, as well as the other innocent, imprisoned Saudi human rights defenders. which brings me to the final case study, and that is that of China and the case of Dr. Wang Bizang as a looking glass into China's human rights violations. Now, Dr. Wang Bizang was a doctor in China who came to Canada in 1979, specifically to McGill University here in Montreal, and graduated with a PhD in medicine from McGill in 1982. But as he put it, while it was important to study and practice medicine, he felt it was more important to work for democratization in China. And so he established the Overseas China Democracy Movement. Fast forward to 2002, he's in Vietnam with a number of his colleagues, where the Chinese authorities abduct him from Vietnam, bring him back to China in a sham closed trial where he is charged with both the crimes of treason and terrorism and unrepresented by counsel and the like. He is sentenced to life imprisonment in solitary confinement, during which time he has suffered a series of debilitating strokes. And regrettably, China in the past few years has intensified its human rights repression, where, as we meet, there's the continued prosecution and persecution of the Falun Gong, the organ pillaging, the plight of the Uyghurs, the concentration camp in China, about which much has recently been written, the arrests of human rights defenders and particularly lawyers in China and the like. A resurgent global authoritarianism that now finds expression in China's relationship to Canada. And let me now just pull these things together. On December the 1st, Canada, pursuant to a Canada-US extradition treaty, arrested Meng Wanzhou, who is a CEO of Huawei Corporation, a technology corporation, at the request of the US, who believed that she was, in fact, breaching secrecy commitments and, in fact, had shared information with China that would be incriminating and dangerous for people in the US and the like. And so Canada has an obligation under extradition treaties to whatever countries they have that treaty, whereby it's a non-political operation. It operates from Justice Department to Justice Department, where if a treaty partner of ours under an extradition treaty, in this instance the US, makes a request for a provisional arrest of someone whom they have reasonable grounds to believe committed a crime not only vis-a-vis the United States, but which would also be a crime in Canada, sought her arrest, and Canadian authorities arrested her on October 1st. There was a bail hearing, and she was released on bail, and she is free on bail, and she has been represented by counsel, and there is an extradition hearing before a judge here in Canada, and it may well be that the judge may determine, for a number of reasons, that the extradition was not warranted, or that it indeed, what she engaged in was not a crime in Canada, whatever. The point is that there is international due process that she has pursuant to the Canada US extradition treaty. However, China reacted to Canada's acting pursuant to an international rule of law principle in the extradition treaty by referring to what Canada did, I'm using the words Chinese authorities, as being vile, unconscionable, and evil, and then proceeded to arrest 2 Canadians, both of whom had long experiences in China, were actually pro-China in their deliberations and research, in respect of whom there is no reason to believe that they had committed any offense. But they have been arrested. They have been languishing in a Chinese prison since the beginning of December, unrepresented by counsel, with allegations that they have been tortured in that regard. And another Canadian who had received a sentence for drug trafficking had his sentence upped from a 15-year sentence to a risk now of execution, and other actions have been taken against innocent Canadians. So if China was saying that Canada had assaulted the rule of law when it acted pursuant to an extradition treaty to arrest the CEO, who is now, as I said, free on bail, awaiting an independent judicial hearing, what should one say about this assault on the rule of law, even in Chinese terms? Which brings me back to the Wang Bizang case and what is, in fact, unconscionable behavior on China's part. Tiana Wang, the daughter of Dr. Wang Bizang, had not seen her father for some 10 years. Recently, she gave birth to an infant son, and she made yet another request which had been hitherto consistently denied. Dr. Wang Bizang's entire family are Canadian citizens, to visit her father, who, as I said, has had several crippling strokes in prison, so that he might have an opportunity to at least see her and his newborn grandchild. Happily, and this is the first part of what was good news, she got a visa to go to China. But the visit to China was scheduled after what I mentioned to you was the whole imbroglio involving the arrest of the Chinese CEO pursuant to an extradition treaty and China's retaliation. And so when she was going, it was against the backdrop of already tensions in Canada-Chinese relations. We advised her, and I had been acting on Dr. Wang Bizang's behalf since his imprisonment in 2002, that there might be a risk of her going to China this time. But she insisted on going because of her desperate, understandable desire to see her father at this moment of plight and pain, and to have the grandson, newly born grandson, see what might have been the only time he might be able to have his grandfather see him for the first time. But when they arrived at the Beijing airport, they were told they could not see Dr. Wang Bizang, and they were put on a plane to South Korea to go back to Canada. But the cruelty doesn't end there. The plane going back to Canada had a stopover in Beijing. And during their stopover in Beijing, as incredible as it sounds, Chinese authorities mounted the plane that was stopping over in Beijing and arrested Tiana Wang and her infant son and put them in prison. We mounted at that point, a real international outcry, etc., and they were released to return to Canada. But Dr. Wang Bizang remains in prison. the pain and plight of his imprisonment a looking glass into resurgent global authoritarianism, there has been no accountability with respect to any of the Chinese officials regarding any of the criminal acts that I mentioned, not only regarding Dr. Wang Bizang, not only with regard to the treatment of Tiana Wang, but all the other massive violations of human rights that I mentioned, be it the persecution of the Falun Gong or otherwise. And so let me end where I began. As I said, this is Genocide Prevention Month. This is also, we meet now on the eve of the 25th anniversary of the horrific genocide of the Tutsis in Rwanda. And there are a number of lessons which must be borne in mind. And for reasons of time, I hope you'll indulge me in engaging only in one-liners, because each of these lessons require almost their own seminar. But for reasons of time, this is an informed group. I'll just summarize it quickly. The first is the dangers of forgetting the victims of these genocides and the imperative of remembrance. The imperative of remembrance of the millions of those 6 million Jews, millions of non-Jews that were murdered in the Holocaust. Those murdered in the first Holocaust of the 20th century, the Armenian genocide. Those murdered in the genocide of the Tutsis, those genocides that I've been referencing, including in Myanmar. We have to realize that the millions murdered here are not just a matter of abstract statistics. That behind every statistic is an individual with a name, with an identity, with a family, with a vision and hope for their future. And so the lesson for us that comes out of this is what we have to realize is if you murder a single person, as our sages tell us, whether this be from the Jewish Talmud or the Islamic Quran, that if you murder a single person, it is as if you have murdered an entire universe. Just as if you save a single person, it is as if you've saved an entire universe. First lesson. The second is the danger of state-sanctioned incitement to hate and the genocide. The Holocaust, the Rwanda, the other genocides, the Genocide Prevention Month referring to, occurred not only because of the machinery of death, but because of the state-sanctioned teaching of contempt, because of state-sanctioned demonizing of the other. As the Supreme Court of Canada put it, the Holocaust did not begin in the gas chambers. It began with words. These, as the court put it, are the chilling facts of history. These, as the court put it, are the catastrophic effects of racism. The third lesson is the dangers of indifference and inaction in the face of mass atrocity and genocide, which, as I sought at the opening of my remarks, to dramatize through the looking glass of the unspeakable genocide in Rwanda, unspeakable because the genocide was preventable. And finally, the danger of impunity, the importance of bringing to justice the perpetrators of these genocides and mass atrocities. Because if we don't bring these people to justice, then what we do is enable and encourage more war criminals and more war crimes. And so may this conference, on the occasion of Genocide Prevention Month, on the eve of the 25th anniversary of the genocide of the Tutsis in Rwanda, may this be not only a time and an act for remembrance, but may it also be a time and a recognition of our remembrance to act on behalf of those who are the targets and victims of such mass atrocities, and on behalf of those courageous political prisoners in these countries of repression who are putting not only their livelihood, but their lives on the line, and where it's our responsibility to speak on behalf of those who may not be able to be heard, to bear witness on behalf of those who may not be able to testify, and to act always on behalf of those who are putting their lives on the line for those values which we seek to uphold and protect. Thank you.
Hi, everybody. So Professor Cotler has to grab a taxi in about 8 minutes, so maybe we have time for maybe one fast question.
Thank you, Professor Cotler. I just wanted to talk about, I had actually two questions. You mentioned Saudi Arabia, and as people may know here, we have a $15 billion trade agreement with Saudi Arabia where we're selling them light armored vehicles, some of which have been documented to be used in the war in Yemen. And I was wondering if you support the cancellation of that trade agreement.
Well, let me just put it into context. When that treaty was signed, I was then a member of Parliament. It was signed by the previous government, the Harper government. I opposed it publicly at the time, and I said we should not be selling arms to a major human rights violator like Saudi Arabia. And this was even before the Yemen war had intensified in the way it has with the use of vehicles that we may ourselves have sold. So I opposed it then. When I was no longer a member of Parliament, the new Liberal government felt it was obliged to honor the contract that the Harper government had entered into. I took the view then that I had objected to the Harper government and that I did not believe that a contract that was being violated by Saudi Arabia in its putting the weapons to uses for which they were never intended, because our sale was effectively contingent on the fact that they would not be put to an improper use or to violate human rights, be it in Yemen or be it in eastern Saudi Arabia against the minority Shiite population. So yes, I was opposed then, continue to be opposed now.
Thank you. My second question has to do with Ahed Tamimi. For those of you who may not know, Ahed Tamimi is a Palestinian girl. She was arrested in December of 2017 by the Israeli occupation forces. And the context of her arrest was there was some protesting of nearby encroachments of settlements on her village in the West Bank. And basically what happened is she ended up slapping a soldier, an Israeli soldier, who was on her property an hour after her cousin had been shot in the head by a rubber bullet and severely wounded. She spent from December to July of 2018, she spent that time in jail as a 16-year-old. She turned 17 in January that year. In that same year, there were 350 Palestinian children arrested by the Israeli occupation forces, as well as 6,000 other Palestinians. And I just want for people to have a mental exercise, if you can imagine the Palestinian Authority arresting 6,000 Israelis and putting them in their jails. I was just wondering what you think about that in terms of, like, you're talking about the retreat of democracy worldwide. We also have in Israel now the basic law, which says that Israel is a nation for its Jewish citizens only. I just want you to speak to that in terms of how that fits into this retreat of democracy worldwide. Thank you.
Okay, quick answers only because I have to fly to Toronto to give a similar talk. But the question is important, and while I can't give full justice to it in the response, I'll just try to say so. You made reference to the nation-state law, the law which declares that Israel is the nation-state of the Jewish people. In effect, it seeks to be one of a number of basic laws to give expression to that notion of Israel as the homeland of the Jewish people, not unlike what one might be seeking in terms of Palestine as a homeland for the Palestinian people, and of course 22 Arab states, which effectively are nation states that have as a state religion Islam, which is fine. I have no quarrel with that. But it does not make Judaism the state religion. It recognizes Islam, Christianity, and the like. I have written critically about the nation-state law. I think it was mistaken in the character of its adoption. I don't object to the notion of Israel being defined in law as the nation-state or homeland of the Jewish people, because that's what it is. I did not favor a law which did not include in it an express reference to equality, which is not an organizing idiom for democracy, but really is an organizing Jewish value. And I had wished that the legislation would have also referenced not only Israel as the homeland of the Jewish people, but that Israel was also a democratic state, something which appears in other laws. But since this was a defining law, to use the words of the Prime Minister Netanyahu, I felt a defining law should have, one, properly given expression to the fact that Israel is both a Jewish and democratic state, two, constitutionalize the principle of equality, three, although it said that it did not change the character of Arabic as a second language, the fact that it appeared to maybe change the character meant that this too requires clarification. And I thought that the Declaration of Independence, the Israeli Declaration of Independence, which speaks clearly and expressly of the importance of equality for all citizens, and that Israel was, yes, a Jewish and democratic state, was also a state of all its citizens, should have been included in the nation-state law. All these suggested reforms I'm still working on, and I hope that the law may be amended as we speak now. It is before the Supreme Court of Israel, its own constitutionality. Finally, on the Tamimi case, that too needs to be contextualized. I've been involved in this whole thing with regard to the Israeli-Palestinian conflict, for years. I'd be happy to, and I've met with Abbas about it on many occasions. I clearly support the notion of two states for two peoples. But I've always added two democratic states living side by side with each other. There are imperfections in Israel's conduct as a democracy. I have been before the Israeli courts where those imperfections, in my mind, have required address and redress before the courts. But that's the point. There is an independent court system to whom one can seek redress. I would wish that the Palestinian people, as I've said to President Abbas, had themselves representative democratic institutions of a freely elected parliament, of an independent judiciary, of a rule of law so that Palestinian people, who themselves, as the reports of Amnesty International and Human Rights Watch recently documented, regrettably, the assaults upon and indeed torture of journalists and others alike by both Hamas and the Palestinian Authority, that there would be a rule of law and accountability on the Palestinian side. So in short answer, yes, there are imperfections in Israeli democracy that have to be addressed and redressed. There is also an absence of democracy itself with regard to the Palestinians. And those of us who care about the Palestinian people should, in addition to being critical of Israel where it deserves to be criticized, also speak up on behalf of the Palestinian people to see that they too can live in a democracy with an independent judiciary, free and fair elections, and the rule of law. So thank you for your question. I would